All right, everybody, we are going to get started right now in talking about estate planning and the 5 essential documents that are needed really for everybody's plan. And that's what I'm going to be covering today. Again, my name is Brian Tully. I enjoy doing these webinars. I enjoy helping folks understand the different elder care and estate planning options as we age, as we plan for our families. Somebody already shared with me that they can see me and hear me, which is good, all the technical stuff. So what I'll share also is if you have any questions, please feel free to put them into the Q&A box or the chat box, and I'll be able to answer them at the end of our webinar. Also, I'm going to be touching upon a lot of different issues today, different documents, different strategies. We're not diving very deep into each of these strategies, but if you want to learn more, you can certainly go to our website, tullyelderlaw.com, and under our events and our past webinars, you can look at the webinars we've been doing for the last 3 years that talk more about different types of trusts and different types of strategies and different types of services. Or even better, face-to-face, you can set up a free consultation with myself, with my team, and we'd be able to address your specific scenario with different strategies and ways to help you come up with the best plan for yourself. Okay, so we look forward to seeing some of you after that. All right, so let's get started. I'm going to share the screen again, and here we go. Okay, so the 5 essential documents when it comes to estate planning. And like always, I think I'm pretty methodical this way. I do like to start off with the foundation, give some definitions so we know what we're talking about. First and foremost then, as most of you are probably realizing, we need to define what exactly is estate planning. And there's a lot that goes into it. I'm not going to give you some type of Webster's dictionary definition. I'm going to share a little more in depth on this screen what it actually involves. Okay, so first and foremost, what people often think about when they think of estate planning, they think of inheritances, and that's certainly true. It's I have a house, I have a bank account, an investment account. I want to leave them to my children. Yes, that's a part of estate planning. It's going to be the who, the what, the when, and the how. Who's going to inherit? What are they going to inherit? When are they going to inherit? And I just don't mean at your passing. I mean different outright distributions or trust distributions. And finally, how, of course, are they going to inherit? As I just shared, is it going to be outright or is it going to be in a trust vehicle so that it's sheltered from certain risks as people inherit and live their lives? So inheritance is certainly a significant part of estate planning. And then so is your health. There are 3 areas of health in our world. There's, of course, the medical, which is going to be when somebody sees a doctor or the hospital or rehabilitation center. But there's also functional aspects of health, which are best defined with the activities of daily living, such as walking, bathing, toileting, and dressing. And finally, there's a cognitive aspect to health. And we all know family and loved ones that have declined cognitively, capacity, etc., whether due to dementia, Alzheimer's related type of conditions. So health plays a role in planning because while the inheritance is after we pass away, there's a lot, as I explained to clients, that can happen between today and that time. So, and that is going to revolve around our medical, our functional, and our cognitive health. So it plays a role. Avoiding courts. I was trying to figure out a more clever way to say it, but the bottom line is we want our clients to lead as simple of a life as possible. And whenever the courts are involved, if you've been through some type of court proceeding in the past, it's always going to be stressful and costly and take forever. So we want our clients, when it comes to estate planning, to avoid the courts. And specifically, it's avoiding a probate proceeding and avoiding a guardianship proceeding, which I'll be talking about more as we go forward. And of course, estate planning also includes a concept of asset protection. There's different risks that we protect again and again. I've talked about these risks more in depth in other webinars on our website. Some right off the top of my head that are crucial and things that we help families with every single hour of every day. LTC, that's long-term care. So we can protect some assets, protect your home, protect some investments in case we need long-term care down the road. And we perhaps want the government benefit called Medicaid to help pay for that. So asset protection in regard to long-term care, asset protection in regard to creditors, and even beneficiaries. And again, I'll get into this a little bit more later, but our beneficiaries, our children, our nieces, our nephews, they might have concerns, right? I mean, in this day and age of divorce, unfortunately, you don't want $1 million, for example, hitting a child, and then they get divorced shortly thereafter, and you end up losing a portion of that inheritance. You do not want to leave an inheritance to a child that may be disabled and on government benefits themselves. You do not want to leave a child an inheritance if they have addiction issues or incarceration problems. So there's a lot of beneficiary issues that have to be addressed when we're dealing with estate planning. And ultimately, taxes. As I share in our consultations, there's different taxes that come into play. There are estate taxes that apply to some families, which goes hand in hand with gift taxation, income taxes, which goes hand in hand with capital gains taxes, and even real estate taxes when we're talking about sheltering or protecting somebody's home. So all of this comes together in the world of estate planning, all right? Now, there's your estate, gift, and income. Estate planning, hands down, 100% is for every single adult. If you're over 18, you should have some of these documents in place. I'm not going to say you need all of them in place, but regardless of your age, regardless of your net worth, and regardless of your health, every adult should have an estate plan in place. At a minimum, a power of attorney and a healthcare proxy for those perhaps college kids. I have 2 children in college right now, and plenty of friends with college-age children. Power of attorney and healthcare proxy. Why? Because once your child is over 18, yes, of course, you're still the parent, but they are now adults themselves. And you no longer have legal authority to handle finances, talk to doctors, etc. So durable power of attorney, which we'll spend some time on, and a healthcare proxy, which we'll also be talking about for those in college. And again, regardless of how much money you have, and you know, you can think of the wealthiest person you see on TV, they have an estate plan, or at least they should have an estate plan. College kids, not a lot of money, right? But they should have an estate plan, or at least some of these documents in place. So there's the gamut, right? 18 or 80, you know, $400 in the bank or 400 million. There should be an estate plan in place, okay? And I also, of course, include health, because you might be healthy. You could be running a marathon every other week. Still need to have an estate plan in place, because we don't know what tomorrow holds, right? That's not up to us. So regardless of you being healthy or declining already, there needs to be a plan. There needs to be documents in place, and it needs to be put together by an attorney that knows what they're doing. Let me go to the next 2 slides, and we'll get into a little more of the complexities. So as I shared in a webinar a year or 2 ago, that estate planning is for every season, okay? As I shared, the younger folks, right, they may not need the complex trusts or anything of that nature. And as we age, we might need to layer on other strategies. But just by way of an example, those of us that are 20 to 40 years of age, starting a career, starting a family, building a family, there is a need for planning. Real brief, you know, we're dealing with minor children. We're dealing with who's going to be watching over them, who's going to be a guardian for them, should, God forbid, the parent's deceased, who's going to monitor and be the trustee over the inheritance. How are those children going to be inheriting? Significant issues when you have minor children that need to be addressed in an estate plan. And then for the next 20 years, right, from 40 to 60 years of age, generally when people are settling in, expanding their assets, expanding their net worth, their businesses, growing their assets, there's other documents that can come into play. That's where the lifetime trusts may be appropriate. A revocable trust is generally utilized for folks that are growing their assets and perhaps real estate in other states or other concerns. And then 60 to 80 years of age, we can call it retirement and spending, because perhaps you're not working, you don't have that active income coming in anymore, then you are spending. Irrevocable trusts, considering asset protection, there's always going to be a need for plan, greater percentage, greater statistic of needing some type of care, needing some type of assistance. And how do you address all that? In writing, by having a plan in place, right? Now, the last category is those 80 to 100. Aging and elder care. We deal with this. This is more than half of the work and half of the clients that we help here at Tully Law every day. And making sure that the plan is in place from season to season, if you will, we're easily able to adapt and update, to modify, to make changes as needed. And that way, this part of your life is taken care of. Get that estate plan done, all right? Now, if you recall the first slide I showed you, we have all these complex areas from inheritances, health, the courts, asset protection, taxation. All of these issues have to be interwoven with these factors, okay? What exactly are the client's goals? What are your goals? Is it to protect the house? Is it to set up a trust for your 22-year-old daughter? Is it to minimize estate taxes? What are your goals? And there can be more than one. In fact, there's usually several goals that we have to flush out together and build a plan around. Also, who are the people that are going to be involved? Is there a spouse? Are there children? Are you not married? Do you have neighbors? Do you have nieces, nephews, cousins? Who are the players that are going to be involved in your estate plan? What are the family dynamics? And I say this to a lot of folks, every family has something going on, all right? It's very, very rare that there is not some type of tension, conflict, issue, addiction going on with every family at some point, and some concern about the son-in-law, or a concern about the daughter-in-law, or a concern about the addiction and the rocky marriage. These things happen, and we can account for them in an estate plan. Other factor is the client's age. Or is the client single? Is the client married? Are the spouses the same age? Are they 55 and 80? Are they 10 years apart? Are they 20 years apart? All of that comes into play, as well as health again. You can't extract health from the concept of estate planning. Estate planning is not just about assets, and I hope I'm showing that here. Your health plays a role, and expectancy plays a role. Diagnoses play a role as we build a plan. And ultimately, your assets do as well, okay? So are we dealing, for example, with a commercial building? Are we dealing with IRA accounts, qualified money? Are we dealing with family limited partnerships where there may be restrictions as to what can happen with that asset? Or we just have a house and we've got $50,000 in the bank. Still, you need a plan in place. One of my hopes as I was putting this together is that folks would realize there are significant complexities that exist in families, in assets, in our lives, and they all have to be flushed out into the plan. I'm not just making this up. Every family that goes through planning, we have to address these concerns. All to say, online software that can build your will or your power of attorney in 5 minutes, or even, with all due respect to other attorneys that don't specialize in this area, they may not be familiar. Going to a real estate attorney or going to a criminal attorney that's your neighbor to get your will done or your power of attorney done may not be the most prudent idea. They specialize what they specialize in, and we specialize and focus on what we focus on. this type of work can be very complicated. And yes, the more complicated these goals, people, dynamics, age, health, assets are, the more complex the plan is, for sure. All right. So sit down with us, sit down with an estate planning and elder care attorney that knows what they're doing and that has been doing this. Ask your friends, go to Google, right? Just Google your name, your town estate planning attorney, elder law attorney. Talk to the bar association, talk to other friends, colleagues, people you work with, and ask who have they used to put together their plan. Read reviews. If you go to Google, read reviews. I mean, you do it for restaurants, right? Do it for the lawyers as well. All right. We're very proud of we've got over 50 4.8, 4.9 star reviews, and we're getting more and more all the time. We've been doing this for 25 years. We've been helping over 1,000 families that we've helped on Long Island, New York City, some in Westchester throughout the last decades. And we've built upon that experience. And then the team and the partners and the staff that I have here, the social workers, the nurse that we have, are all to make sure that your plan gets put into place correct and that we can modify and grow with it as we get older, of course. Okay, so now let's get on to those 5 estate planning documents. All right, so first, of course, it's going to be the last will and testament. And the next slide, we'll talk about it a little bit more. The second document is a power of attorney. The third is a healthcare proxy. The fourth is a living will. And for those of you that thought those are it when you're talking about planning, we've been recommending more and more trusts for everyday people and everyday situations. There's different types of trusts, what we'll talk about today. So I don't think you can sit in a meeting with me or my team and we won't talk about a trust. There's a lot of solid reasons to have one type of trust or another type of trust. Okay, so that's why I'm calling this one of the essential documents. And it's kind of a twofer. You know, it's not just one type of trust. There's a revocable trust for some circumstances, and then there's an irrevocable trust for others. So depending on all the factors we spoke about, age, dynamics, assets, health, we'll talk about revocable or irrevocable. Okay, so if we get one question here or one thing that people say the most when they call, it's I need a will. And that's fine. They call, that's their understanding. That's the point of them reaching out, and that's great. But a will is, and I did a webinar last year just saying estate planning, it's more than just a will. But at least, again, that's opening the door so we can talk about the needs and the strategies to help. A will itself is just a written document. All right. Can it be oral? Yes, but that's a whole nother complex issue. A typical last will and testament is written. Interestingly, and a lot of people don't realize this, so I always like to make a point of it, is the will does not govern every asset that you own. It does not distribute every asset you own. A last will and testament only distributes assets that are in your name alone, okay, solely. So if you have a joint bank account and pass on, that joint owner is inheriting that account because they're a co-owner with you with survivorship. If you have a life insurance policy with your spouse named as a beneficiary, that's not going through the will either. Why? Because there's a named beneficiary. They fill out the claim form, they get the asset. Or if you have a trust in place that owns the home, that trust will dictate when you pass away who's going to inherit the home. Okay, so that way, when you have joint accounts and beneficiary accounts or assets owned by trusts, it does not go through the will. And that's the point. That's the plan. I tell clients every day, you need a last will and testament, but you don't ever want to use it. Why? Because it's not effective. It's not a valid last will and testament until the court says so through a probate proceeding. Now, again, we'll talk about that a little bit more when we're talking about trusts. Probate can be avoided. Probate should be avoided. Significant delays, cost, expense, stress, lack of privacy. And again, I'll reiterate that a couple more times today. Stay out of the courts. All right, come up with an estate plan to keep the family out of the courts. In this day and age, Suffolk County pre-pandemic was pretty darn quick. We'd have a 2-3 month delay. The process, the probate proceeding would be nearly complete. They are at 8 or 9 months now, and unfortunately, it might only get worse. The city is a year plus. Nassau County is a little better than Suffolk, but still, why go to the courts if you don't have to? So we want to avoid the courts. We want to avoid using the will, even though you need one just in case. The next document that's essential, and I'll even tell some folks that this is probably going to be the most important document that you put together. It's what's called a power of attorney. Now, the first little bullet point I have here is it needs to be, at this stage of the game, it needs to be a 2021 form. New York State has made the power of attorney a bit more complex than it ever needed to be. They updated the form that the legislature approved back in the 90s. That's fine, but they changed it again in 2009. They changed it again in 2010. They changed it again in 2021. It is a complex undertaking. With that said, I can't think of a more important form to have done right and in place as we age, okay? And what you're doing is you're appointing somebody to be a fiduciary, an agent, to help you with your legal and financial affairs at any point in time. Now, generally, if I have a power of attorney appointing my wife. Now, I'm handling bills, I'm doing this, I'm handling that. We don't need her to use the power of attorney to help me, so it's just sitting there in the drawer. But if something should happen to me, God forbid, she then has the legal authority to step in and assist, to pay bills, to sell the house if we ever had to handle financial and legal affairs, okay? The power of attorney must be durable, meaning that the power of attorney will remain valid even if I were to lose mental capacity, okay? In olden days, when somebody had a power of attorney or appointed an agent to help them, if the principal, who's the person who signed the power of attorney, lost capacity, lost the ability to handle their own affairs, then the agent could no longer act on their behalf, and it's all for nothing. But this concept of durability was created, which means the power of attorney appointment of the agent remains valid even if I lose capacity. So it has to be a durable power of attorney. And I'll say even more important, but just as important, is the power of attorney must be modified. If there's one thing I say more than anything else all week long, it's talking about a durable, modified power of attorney. Cannot express to you enough how crucial that the power of attorney you have has the appropriate modifications built into it. That standard power of attorney New York State created and modified in 9, 10, and 21, it's not worth the paper it's printed on if you're just using that form. It's so very limited and does not allow your agent to handle estate planning, aging concerns, elder care, long-term care, retirement issues, business issues. All of those added powers need to be put in to the standard statutory form. Those are the modifications. You need a power of attorney that is going to be built to last as you age, durable with the appropriate modifications. If you do not have a power of attorney, or if you do have a power of attorney without the right modifications and you lose capacity, you're going back to court for a guardianship proceeding. Again, on the first slide there, we want to stay out of the courts for probate, like I just spoke about, and for guardianship. And you can do that if you've got the right power of attorney with the right modifications, okay? Worth its weight in gold, all right? Now, then we get into our two healthcare documents. The first one is called a healthcare proxy, and I'll share, I have plenty of good, respectable, experienced colleagues that put the living will and the healthcare proxy together into one document. We do not do it that way. And I'll explain why in just a moment. So healthcare proxy is one document. The next document, the living will, is a separate document. In a healthcare proxy, you are appointing one person at a time, because you can have successors here. Everybody we pick for a role should have a backup. Executor, trustee, power of attorney agent, healthcare proxy, have a backup, all right? So you pick one agent at a time. Power of attorney, you can do more than one, but healthcare, just one at a time. And they're there to talk to doctors and make decisions for you if you can't do it yourself. All right. If you're still able to make your own decisions, then you do that. But if you can't, this is where you have this form. It should include HIPAA provisions. HIPAA is a privacy release where you can name your healthcare agent to access what's called your personal health information, which is medical records, etc. The standard healthcare proxy form needs to be tailored. So if you have a form from the hospital when you were admitted for that appendectomy 20 years ago, it's going to be missing a sentence. It's not, again, the right one for aging and for estate planning. There needs to be an addition of a sentence that says, my agent knows my wishes about artificial hydration and nutrition, all right? That way they can make a decision for you based on or in regard to feeding tubes, okay? Now, again, unlike the power of attorney, if there is no healthcare proxy if there is no healthcare proxy in place, New York State does have something called the Family Healthcare Decisions Act. So if there is a loss of capacity and you're unable to make a decision, New York law says your spouse can do that for you. If there is no spouse, then a child can do that. If there is no child, then there's a hierarchy, okay? Other relatives, siblings, partners, etc., can help make that decision. Would I want you to rely on that? No. I'd rather you have a healthcare proxy naming the person you want to help talk to doctors and make decisions, okay? Then we get into the living will. And again, separate document. It's a general statement that says that if I am ever in an irreversible or incurable condition, I do not want medical treatments to keep me alive artificially. So the living will is the end of life document, okay? And it does get into some specifics, such as if I'm at that point, I do not want ventilators. I do not want dialysis. I do not want antibiotics. I do not want ventilators. I do not want feeding tubes. But do give me pain relief, okay? So if I'm at that point of no return, then I do not want A, B, C, and D, but I do want pain relief. And as I shared, we do it as a separate document. Why? Because I want the family to be in control as much as possible, all right? So by having a healthcare proxy in your hand here, and then having a living will at home, okay? If your loved one is in the hospital, give them the healthcare proxy. That proves that you are there to make decisions and to help. But it may not be time yet to talk about end of life concerns. So I don't even want to put that on the table, okay? There have been studies in the past, and as awesome and as needed as doctors and nurses are, there can be mistakes made as to what a living will truly means. And there have been mistakes made. So I don't want to put too much out there too prematurely. So healthcare proxy gets filed with the court, with the hospital. It's in your chart. You're there to make decisions. If it is that time to talk about end of life, and the physician comes to you and says, did your spouse want a ventilator? Are we going to do feeding tubes? And if they're not able to make their decision, you can say, no, we don't want that. He didn't want that. She didn't want that. And they're going to say, okay, how did you know that? And you can say, we've had these conversations and I have a living will right here. Okay. And that living will say, if I'm ever at that point, I do not want those types of treatments. Okay. A nice general way to kind of share how these things work. The living will does not apply, as I put it, to 911. Okay. So car accidents, cardiac events, and so forth, it could, but if you've got EMS showing up and they are at your door or they're getting you into the ambulance, that's what they're going to do. They're getting you into the hospital. You're going to be stabilized. It's at that point where conversations might happen. Okay. And again, that's just in a typical situation, not getting into DNRs, not getting into all that. Okay. So this being our fourth, all right, essential document, we're then going to get into a trust. All right. A trust is very appropriate for most scenarios. A trust is not some estate planning strategy for the Vanderbilts and the Kennedys. Okay, it is more and more for everyday people. It's nothing more than a written agreement. All right, broken down into different parts. It's a written agreement between two people. What's called a grantor, that's the creator of the trust. They're granting the trust. Some attorneys call it a settlor or a trust maker. Grantor to me makes more sense, so that's what we've been using. So it's a written agreement between a grantor and a trustee. The trustee is the manager. All right. Now, depending on what type of trust this is, the grantor and the trustee might be the same person, or the trustee and the grantor may be different people. All right. So again, a trust is a written agreement. It deals with management and use of property while I'm alive and healthy. And then it's going to be the management and use of property if I'm alive and not healthy, because you'd have a successor trustee involved. And then finally, the written trust agreement is going to talk about what to do with my assets when I'm gone. All right, the assets that are owned by this trust. You might put your house into the trust. You might put $100,000 stock account into the trust. And this trust, again, is a written agreement saying, all right, I'm alive and well, do this with the money, do this with my house, let me live there, etc. But then if I'm not well, if I lose capacity, then do this with the trust. And ultimately, when I'm gone, this is how I want everything distributed. Okay. Now, two types of trusts. Just looking at the clock here. All right, two types of trusts. And don't forget, if you have any questions, stick them in the Q&A box. There is a revocable trust and there is an irrevocable trust. There are many differences between the two. I generally, however, share that there's two main reasons or two main differences between these trusts. Okay. Now, avoiding probate is one of the main goals in having a trust. So is asset protection. Okay. So when we're sitting with somebody, avoiding probate is one goal, asset protection is another. And then as we learn more, okay, are we looking at the revocable trust or are we considering an irrevocable trust? So a revocable trust, as again, you've already heard me say 10 times and I'll say it 10 more times. The revocable trust is about avoiding probate. Okay. Now, an irrevocable trust, guess what? Also avoids probate. That's a good thing. Now, an irrevocable trust, which I'll talk a little bit more about, is irrevocable. And it's irrevocable for a reason. It's because we're trying to shelter or protect assets. Okay? So an irrevocable trust does two primary things. It avoids probate and it protects assets. Now, the revocable trust avoids probate. But because it's revocable, which means I can set it up and I can take the money back, there is no asset protection with a revocable trust. All right. So in some circumstances, it's irrevocable trust all the way. In other circumstances, it's revocable trust. Okay. If I'm sitting with a client, husband and wife, 65 years of age, they have a house and they've got some money, we're talking irrevocable trust. Why? Because we might need help with long-term care expenses when we get older. We might need Medicaid. So we're going to do an irrevocable trust to shelter that home and maybe some of the financial accounts. On the other hand, if I'm sitting with a 65-year-old couple worth $12 million, we're not going to be considering Medicaid down the road. They're not going to be eligible, and it's not going to be an appropriate step for them. So we might be focusing on a revocable trust. Okay. Yes, there are irrevocable trusts for estate taxes. And again, another time, another webinar. But generally speaking, a revocable trust would be a more appropriate tool for them. Okay. Hopefully that helps. Why do I need a trust? So there's a laundry list, as you can imagine, of reasons to have a trust. Asset protection for long-term care, perhaps. Probate avoidance. Why do we want to avoid probate? The time delay, the costs, potential contests, challenges within the family, a lack of privacy. Beneficiary issues, another reason to have a trust in place. Why? Because, as I've mentioned in the beginning, the potential divorce, rocky marriage situation. Are they not good with money, making poor decisions, taken advantage of by others? Or is there an addiction that we have to be aware of so that the money isn't misused? Another reason for a trust is creditor protection and ultimately estate taxes. Okay, so just various reasons why a trust is used more and more. And just as an aside, years ago, pre-pandemic, even before that, if I was sitting with a 40-year-old client with a house, a couple $100,000, a retirement account, I would have been all right with a will-based plan. The will, power of attorney, healthcare proxy, living will. And especially if there's a spouse there. But in this day and age, post-pandemic, that type of a client, we're going to be talking about revocable trusts. They've become more and more important because of the problems with the courts, okay? I mean, go back to COVID. Everything shut down. There were thousands, in New York alone, thousands of estates and wills that were just frozen because the courts shut down. And it took months, if not a year, to catch up after that. So because we know things can happen, we want to stay out of the courts and keep things private. Doesn't mean you have to do a revocable trust, but it does mean we want to talk about it and we want to recommend it. All right. So a little bit more about the revocable trust, a slide or two to talk about that. Now, in a revocable trust, it's revocable. It's a revocable written agreement. It's the grantor, the one setting it up, the client, has 100% of the control and 100% of the access to what's inside the trust. Control and access. That's the big difference between the revocable and the irrevocable, okay? A revocable trust allows you to consolidate your assets. As an aside, you never put your retirement accounts into your revocable trust. You keep them in your individual name. But if you have the real estate, 2 houses, 3 houses, different investment accounts, bank accounts, you consolidate them into one trust entity. It, of course, as you've heard me say 10 times, avoids probate. It allows you to build in contingencies. Let me spend a moment on this. If I've got a client who has 2 children and they have a $200,000 investment account, I'll talk about a revocable trust. They'll say, I don't need a trust. I have my kids named as beneficiaries on that account. Great. They'll avoid probate upon your future passing. However, what about the risks? What about the contingencies? What if your kids are 14 and 16, God forbid, when you pass away? A trust that owns your $200,000 investment account can have contingencies built into it. So if my beneficiary is underage, then this happens. The money gets held and protected. If my beneficiary is not healthy, disabled, on government benefits, then this happens. If there's, if you know there's a rocky marriage, if again, you know there's an addiction, you're able to account for all of that within a trust. You can't do that with a beneficiary form, okay? So revocable trusts provide a lot more contingencies. It's 40 pages of options, right? So it's worth having. And finally, a revocable trust, no asset protection at all. Why? Because it's revocable. I can put money in, I can take money out. I have all of the control and all of the access. If I have access, then so do my creditors. If I have access, then so does Medicaid, okay? So a revocable trust is not about asset protection. Some more points about the revocable trust. It allows you to maintain privacy. It saves time. It allows you to skip that 7, 8, 9, 10, 12-month probate process. Faster access to money, faster inheritance for the children, saves money, right? Legal costs for the probate proceeding, court filing fees, no need for a bond. We have clients that have to probate the parents' will. The court says, I don't know what this, I don't like the way this will leaves everything to you. I don't like this scenario, or your credit score, right? As a potential nominated executor isn't as great, or you've had some type of a criminal history in the past that was or wasn't your fault. The court can make you become bonded, which is basically an insurance policy for your executor. Premiums can be $5,000, $10,000, $15,000 that have to pay for that. So again, more costs when you go to court. When you have a revocable trust, you're skipping the courts. When you're going through probate, the court will require your heirs, your distributees as they're called, to sign off on that will. If you have 3 children and you're leaving everything to one child, which is certainly your choice as long as we've got the right capacity, then those other 2 children aren't going to be too happy. If that one child beneficiary has to probate your will, the other 2 have to sign off on it. Do you think they're going to sign off on that easily? Absolutely not. We've got this going in several different circumstances right now. So by avoiding probate, we do not have the court requirement to bring the other siblings in, the other children in, okay? Avoids ancillary probate in other states. House in New York, house in New Mexico. Pass away with those properties in your name alone. We have to do a probate in New York, and we have to do a probate in New Mexico. 2 probates. So outside real estate, really, a revocable trust is a no-brainer. You're not required to locate missing heirs. Again, go back to court. If we're in a probate proceeding, and let's say there's no children, and we just had one go 6 years, 6 years. We had to hire genealogists. We had to go back through Ireland, through family records, 6 years. And because there's no next of kin, the court needs to rule out who is involved and who is not involved, okay? So again, the courts, you don't want to do it. If there's a minor child, let's say, and we've seen this too, a husband and wife with a minor child, say a 12-year-old, one parent is deceased. If assets are going to that 12-year-old, the court is going to require a guardian to be appointed over that 12-year-old, even though the other parent's alive, okay? Why would you want that? You want to skip that. In working with a bank, and these guys are getting harder and harder, not as bad as the courts, but if you go to a financial institution, think of an investment company or bank with a power of attorney, again, better than nothing. Having a power of attorney on file at a bank or financial company is great, but a trust just goes a little bit smoother because you're the trustee of your trust. But if I'm incapacitated or passed on, then automatically the successor steps up and they just stand in my shoes and handle what I got to handle. And ultimately avoids or minimizes estate recovery. In the world of Medicaid, if somebody is on, all right, Medicaid benefits and they pass away with an account in their name alone, New York State gets that back, okay? If we have that account joint with somebody else or in a revocable trust, the state does not get paid back, okay? In addition, not that this works definitively, but in a spousal situation with Medicaid, having the non-Medicaid spouse assets in a revocable trust will again save time and money if they pass away first, because then the assets go to the children directly with that trust administration versus the courts. Okay, so again, revocable trust, definitely a priority for clients, for families, and we are really recommending them in more and more circumstances just because probate in the courts has gotten that much more ridiculous. All right, I got to speed it up here. And I thought this would be a short webinar. The irrevocable trust. The point of an irrevocable trust is to protect from Medicaid. There is limited control and access. We do not eliminate control and access, we limit it, okay? It again avoids probate. We use these every day. We've got families coming in for our elder care protection service, and the irrevocable trust is used consistently. Let me give you a couple points as to the details with the irrevocable trust. First and foremost, when an irrevocable asset protection is set up, we need to be aware of the look back period. That's the review or the waiting period, if you will. For nursing homes, it's 60 months, which is 5 years. For home care, it's still 0, but next year it's going to be 30 months, 2.5 years. The reason the asset protection trust or the irrevocable trust is an asset protection trust is because when you put something into that trust, you can't pull it out again, and your trustee can't give it to you. That's how we gain the protection. It's about access. Remember I said control and access? We have to limit your access to what's inside that trust. So if you have $100,000 in that trust, you cannot go pull it out and the trustee can't give it to you. If you could go pull it out, then you have access. And if you have access, then so does Medicaid. So because this rule is so strong, we always have enough money left outside the trust to live off of. Not everything goes in this trust. And we build in a back door. So money can come out of the trust if necessary, but it has to go through the children or through other people that you pick. You can receive the income if needed. If there's a house, you've got the right to live there. Your real estate taxes remain the same. You don't lose your exemptions. The house can be sold. You can buy a new house, again, with the trustee. You control the trustee. So if you pick your child, your eldest child as your trustee, and God forbid there's a falling out, you can fire them, okay? Same thing with beneficiaries. So even though it's an irrevocable trust and you've got 3 kids, you can disinherit one, or you can add the grandkids or add a charity. You're able to do that with an irrevocable trust. It's not completely limiting your control, okay? Taxes, apart from the real estate taxes, your income taxes remain the same. You're still paying income taxes on the money in the trust, the income that's generated, which is a good thing because of the way the trusts work. Capital gains taxes, that's on growth and profit. So like your house, as of right now, if your children inherit your house from you, they receive what's called a step up in the basis. They inherit at fair market value on the date of death. The trust keeps that, okay? So you're not getting hit and you're not getting harmed tax-wise. What else? Remarkably, even though it's an irrevocable trust, it's revocable, all right? I can count on one hand how many times we've done that in 25 years, but just to know you have the ability to do that, as long as everybody agrees, then it's certainly doable, okay? Irrevocable trust, like I've shared before, worth its weight in gold, a very common tool and strategy that we're using every day of the week. Now, in putting together these services, there's a probate avoidance plan, which is going to be the last will and testament. Technically, it's what's called a pour-over will. It complements the revocable trust. It's that durable modified power of attorney, the healthcare proxy and the living will, like we've discussed, and the revocable living trust. So this is a specific intentional plan that we do with clients. And this, again, doesn't matter your age or your health or how much money you have. You want to stay out of the courts, and this is the way to do it. Another plan that I just mentioned to you a few moments ago is what's called an elder care protection plan. This is generally for those 65 years of age and over, where Medicaid might be a reality. My own parents have something like this in place. And believe it or not, Medicaid is going to be a reality for a lot of people. Paying for home care, paying for nursing homes. A nursing home could be 20 grand a month. Home care could be 100 grand a month. Nursing home care can be 200 plus per year, per year. Medicaid might be a reality or a possibility. You at least want the option. So what do? You come and talk to us and we'll share the options and the possibilities. And then you protect your assets, not all of them, protect some of them, so that if you want Medicaid down the road, you have the ability to look at it and know that the house is protected. So again, it would be the will. It's that very comprehensive, durable, modified power of attorney, the healthcare proxy, the living will, and of course, our irrevocable trust. Okay, so this is appropriate, again, 65 and over, get the elder care protection plan in place. Now, I'm finished. So questions, all right, some questions have been popping up. If you want to talk to us directly, email me, Brian at TullyElderLaw.com. Brian with an I at Tully, Tully, elderlaw.com. Phone number 631-424-2800, 424-2800. All right, thank you very much. Now let me get to the questions. All right, folks. I was in the hospital and rehab. I'm 80 years of age. Can I get Medicaid and save my co-op and give it to my son? Gene, I'm going to say probably, but there's a lot of factors that go into Medicaid eligibility that I certainly don't know the answer to right now. The most important thing to do would be to call and schedule a consultation where we'll talk about our life care services, which includes all the Medicaid work and the protection, if it's even possible. But it could be, all right? Can I put my home in a trust if it's not fully paid off? Great question, and the answer is yes, all right? Even the irrevocable. The bank cannot foreclose, the bank cannot accelerate. You have a right to live in the house, so you're good. And Richard, yes, an irrevocable trust can be revoked as long as all of the parties agree, the grantors, the trustee, the beneficiaries. Can I put a co-op in a trust and then file for Medicaid, or do I have to wait time? So if you own your home, a house with a deed, or you own your condo or townhouse with a deed, you could do whatever you want with it. You can put it into an irrevocable trust. With a co-op, you don't actually own a deed. You own shares of stock and you have a lease that gives you the right to live there. The managing board, they decide whether or not you can put your unit into an irrevocable trust. So you have to ask them if an irrevocable trust, irrevocable, is permitted. Now, is there a waiting time? Whole nother question. That deals with the concept of a look back period. So as of today, as of the rest of this year and next winter at least, there is no waiting period, no look back period for home care. So you can protect your assets and apply for home care. You would use us and our advocates. We have care coordinators on staff. That's what we're known for. I have a registered nurse on staff, a geriatric social worker on staff. We help the family navigate the entire long-term care system. So yes, home care, no look back period. Nursing home, though, you've got the 5-year issue. What does a bond mean? Well, a bond, as I was talking about in the context of probate earlier, it's like an insurance policy that the executor doesn't steal the money. Okay, so if there's $1 million of assets in the estate, the court might require that the executor purchase $1 million bond. That way, if there's, again, let's just say stealing, then that $1 million insurance policy would kick in so the beneficiaries get that money. Life estate for the home. Next question. So a life estate is a way to protect the house. It's a very, very limited way, Michael, to protect the home. We probably do one a year at this point. The circumstances have to be right for it. The reason we do not like life estates is they're too simple. There's no contingencies built in. If a child predeceases, now what? Where does that interest go? If that child is getting divorced, if that child is ill, if that child's on Medicaid themselves, if dad needs to sell the house, he can't do it without those children being involved. And even then, if they agree, dad's only getting about 10, 20% of the house. The rest of the money goes to the kids and they pay capital gains taxes on it, okay? If dad wants to change his mind as to who inherits, he can't do it with a life estate. So life estates exist. Very, very limited, and that's why we don't like them. We always like to have options and flexibility, which is why the irrevocable trust is better. All right, for a typical simple estate with 2 properties between 1 and 2 million assets, what would the probate avoidance plan cost? So, not going to play the lawyer here. We do have set fees based on the work that we're doing, but a revocable trust plan with different properties, you're probably in, and again, things matter whether it's a single individual or a spousal situation because it's twice the work there. It's not twice the fee though. You're going to be somewhere in a $6,000 to $7,000 range. Okay, generally speaking. Obviously, I reserve the right to change that based on details. Do you have the presentation on your website or can be printed? So Phil, thank you for joining us. By tonight, this webinar will be on our YouTube channel for Tully Law Group, and it'll also be on our website. Okay, so you can certainly download or watch the video, the webinar presentation that way. Phil, reach out to me and I can send you the slides if you'd like, or just text me again. The fees for the documents. Again, Myrna, I'm happy to talk about that in a free consultation because the fees depend on what we're doing. It's been 25 years. We've been building estate plans for clients. By the grace of God, we've been growing every single year and helping more and more families. Why? Because I think we charge fair fees, and we are all about helping you, not just for the transaction of filling out a form. It's not about that. It's about creating a plan. It's about protecting assets. It's about providing for your children. It's about having peace of mind. So there's a value to that. So specific fees based on that, I don't know how to exactly answer that except to share. Be happy to talk to you and learn more about your details and give you a specific number then. What is better for property outside of the country, revocable or irrevocable? That's a tough question, Cheryl. It depends, okay? Excuse me. What you're looking at there is the other country's rules as well as to what can happen and what can't happen. All right. So it's a process. You might have to even engage in, an international lawyer or a lawyer from that country to help. I'm going to say thank you very much. Yes, we will be starting the continuing education courses for social workers again. Thank you for asking, Stephanie. Thank you all for joining me. And again, get on our email list so that you get our next webinar. We spent nearly an hour talking about this stuff. Any other questions, please reach out. TullyElderLaw.com. Look forward to seeing you again. Thank you. Bye-bye.